affidavit in item number 15.
Item number
15, I find it 1-5. On behalf of the petitioners.
Okay, bring it.
And may I please, I beg to mention for listing on motion matter will.
Motion.
Yes.
When?
Tomorrow.
Is it urgent?
Arjun Miller, selection of
No,
president.
this court will rise early tomorrow. So
Arjun Miller, Tuesday Miller.
Tuesday.
coming.
If it is very urgent, we can have it tomorrow.
Yes,
Motion.
tomorrow morning.
We'll try.
Please.
May I please, your lordship, I beg to mention item number 3, lordship.
Yes.
In this case, lordship, we need to file a rejoinder against the affidavit in opposition filed by the respondent number 6, lordship. So
You
1
have
week
for
time.
6?
No, lordship. No, I've taken consent from the opposite party, lordship.
Okay.
So 1 week time may be given, lordship.
Oh. On a prayer made on behalf of the petitioner, 2 weeks' time is granted to file rejoinder affidavit against the affidavit in opposition of the respondent number 6.
6, available.
Right. My pleasure, lordship.
No interim order, I think.
My pleasure, lordship.
Yes.
With a consent of others, I beg to mention item number 12, lordship.
12.
Kindly adjourn for the matter for a day, lordship.
Okay.
Please for.
On a request made by Sri Ali, Learned Standing Council, Election Commission of India, matter is adjourned to be listed after a week.
Kindly fix a date, your lordship.
First week of September, lordship.
Adjourned to be listed in the first week of September.
Obliged.
May I please, your lordship?
Yes.
Lord, I beg to mention item number 4 and 5, my lord.
Yes.
Lord, the revenue on the last occasion, my lord, took time to file an affidavit, and today morning, my lord, I have inquired in, my lord, they have sent the affidavit for waiting, my lord.
Hmm.
So, my lord, may I pray that this matter may be taken.
Yes,
up
Madam, revenue.
Next
We
week, my lord.
require another 2 weeks time. Lordship.
2 weeks' time.
Lordship.
Okay. 4 and 5 are connected.
My lord, connected matters.
Okay. Miss G. Hazarika, Learned Standing Council Revenue Department has submitted that the affidavit in opposition has been sent for vetting. Vetting
Yes, Lord.
has been prepared. That is being prepared. And some more time would be required to file this in. How much time?
2 weeks. Lordship.
List after 2 weeks. On request, on request, list after 2 weeks.
Lord, there is an interim order of.
Interim order passed earlier to continue till the next date of listing.
My lord,
Deeply.
obliged, my lord, deeply obliged.
May I please, your lordship? I beg to mention item number 8. Lordship, we've been newly engaged in this matter. We have to file our wakalatnama. And also,
When are you engaged?
lordship, yesterday, we got to know. about
14
the-
matter.
Yes, lordship.
Let it come, 14 matter. Yes, Revenue Department, what is this matter, 14 matter about?
Lordship, this is regarding acquisition compensation.
Okay, new council will fix a date. But the minimum possible time, 14 matter.
Land acquisition compensation.
What is,
Yes.
what is your name?
K. Bhattacharya.
Ms. K. Bhattacharya, Learned Council, has informed this court that she and her colleagues have been,
Counsel Mr. G.N. Sahewala has been engaged.
that her seniors, G.N. Sayola, has been recently engaged and the formal wakalatnama is required to be filed. Full stop. Para? According to she prays for some time. Para? Considering the above submission and also the fact that this writ petition is pending since the year 2014, a week's time is, accommodation of a week is granted. Full stop. Please for hearing on on 2nd of September.
Lordship, we have to file IA also. The petition number 3 and 4 have
The
expired.
first file I will see 2nd
Gotcha.
September. Yes,
May it please, your lordship. I beg to mention listing of an item.
listing of
Writ petition.
for motion,
No, my lord.
then
Admission.
matter of which year?
New matter, my lord. Eviction matter.
Eviction matter. When was it last listed?
Lordship, it was earlier first listed before the vacation bench, and then it was last listed on 11. Your Lordship has further perused that all the steps have been taken. So your Lordship had granted 1 week's time, but Lordship, it has been already 10 days. Still, it is not yet listed.
Why were you approach the registry if 10 days expiry is there? Out of turn, listing, a mention memo is only for urgent, some urgent, extreme urgent matters, not for this. Approach the registry.
Obliged.
When was the last order passed?
Lordship, it was passed on 11.
Apprise the registry that 10 days time was granted, 7 days time was granted. Yes,
May it please the court. Your lordship, I beg to mention item number 11 on the daily list. The discussions for one-time settlement between the parties are still ongoing, so we are seeking an adjournment for today, your lordship. I've obtained the consent of the other side.
Ms. Amdas.
Yes, your
Learned Counsel for the applicant has submitted that some talks of settlement are ongoing and accordingly she prays for some time. Para, list after 3 weeks.
Oblige, your lordship.
May I please, Lordship?
Yes.
May I please, Lordship? That's why I beg to mention item number 7.
Item number?
7, Lordship.
Yes.
Lordship, in this case, I am facing some.
17 matter.
Lordship, at least 2 weeks time more.
Why?
Lordship, we are second set of council, Miller, and petitioner residing in Australia, Miller. I have since 2018, I lost his contact since after NSD.
Then if his petition is
Lordship,
not,
at least last chance, I'll try to, today morning, I'm trying to contact one his
Sri M. Mohanta,
Lordship.
Learned Counsel for the petitioner, has submitted that since the petitioner is residing abroad,
Lordship,
there is no contact for a long time.
Lordship,
Full stop. He accordingly prays for some accommodation
Lordship.
to have some instruction. Para. Considering the aforesaid submission as well as the fact that this writ petition is of the year 2017, a short accommodation is granted directing listing of this matter on 2nd of September.
Lordship. Hi, Lord.
May I please, your Lordship? We have a listing, Lordship, for withdrawal, Lordship.
With earliest.
Lordship? August.
May I please, your Lordship? Lordship, I am praying for listing of an writ petition, which was last listed on 16/7/2025.
16/7, why?
The matter pertains to be regarding an representation which was submitted to the deputy.
There is no urgency, no out of turn.
Lordship, regarding demarcation of land.
What is the urgency? Mention memo is only for urgent matters. It will come on its own. Yes. Yes. EPF. Yeah, for EPF.
Hello.
Yes.
Sir, I've been appointed today actually. We are filing the reply on this particular writ petition. Will be allotted for 2 weeks time, my lord.
But in that case, the interim order has to be extended. Mr. Rathi will issue a notice. Yes.
My lord, may also direct to defreeze my bank account because my lord, I am unable to do my operations. 45 lakhs rupees, more than 45 lakhs rupees has been seized from my bank account, my lord. The ongoing operation and the authorities have the power to attach my property, which is worth 11
What do
crores.
you say, Prafasai?
My lord, they have been defaulting since 2009. And moreover, they have changed.
No,
the-
he says that it's a separate, different entity.
Absolutely, but by the act, my lord, by section 17F, it is already declared that if they have, the establishment has been shifted, my lord, at that point of time, they should have informed. They have not even informed. And all the infrastructures, geographical locations are same as it is.
My lord, the establishment, there has
Okay,
been no-
this order will remain, no coercive. The other one, a mandatory injunction kind of a order will not pass, but not 2 weeks. You file your affidavit
May I please?
within a period of 10 days. Okay, yes.
My lordship, in this case, what happened? PAN number of the petitioner and the PAN number of the account is the same. For that reason, the bank has put lien on the account. Now the respondent number 2 has issued deemed defaulter notice to the bank officials. directing them to pay the amount. So instead of taking action against the petitioner, they are now
You have to file an application.
Yeah, I will file.
You file your application.
Yes.
Lordship may kindly come to my lord, because my lord, my ongoing operation has been adversely affected, my lord, because of this freezing of the bank account. And
Heard Sri D. Rathi, learned counsel for the petitioner. Who has put to challenge the 14/8/2025 order first. Sir. This matter had come up for consideration on 14/8/2025 when it was directed to be listed. Full stop. On the next date, that is 18/8/2025, one counsel had appeared on behalf of the respondent number 2, Assistant Provident Fund Commissioner, and sought for time to seek further instructions. Ms. Dasgupta, is it to you, madam? Yes?
My lord.
Okay, okay. Okay. Para? What is your name?
D. Nandi, my lord.
D. Nandi. Let notice be issued, returnable. Notice be issued. Three. Who will appear for Union of India, Ministry of Labour? Sri S.S. Roy, Leonard CGC, accepts notice on behalf of respondent number 1. Sri D. Nandi,
D. Nandi.
Learned Counsel for respondent number 2, and Sri 2 and 3, 2 and 4.
My lord, for 4, it is maybe expunged because they are not connected to this particular case.
I think 4 you can take. Central Provident Fund Commissioner. Can you take? No. Okay. 2, and Sri Parvez for respondent number 3. Let steps be taken for service of notice upon the respondent number 4 by registered post with AD. Para. 3. Rathi, the learned counsel for the petitioner, has prayed for an interim order by submitting that because of the action of freezing of the bank account, the day-to-day activities
I'll place indemnity bond, my lord.
of the petitioner is being adversely affected. Full stop. On the other hand, the learned counsel for the respondents have opposed the interim prayer. Full stop. This court has noticed, that on 18/8/2025, an interim protection was granted that no coercive action be taken against the petitioner in the meantime. What about indemnity bond?
My lord, in that regards, I would like to say, my lord,
Okay,
that they have already
okay.
taken lots of adjournment.
Considering
My
the
lord, I'll place indemnity bond, not a show cause notice was issued. I was not issued a
Okay,
single notice. All of them was issued to Hotel Borel.
considering the
Absolutely wrong, my lord.
considering the rival contentions, while the earlier interim order is extended, the aspect of defreezing the bank account would be considered on the next date before which the affidavit is required to be filed. List after 10 days. We fix
My
that
lord,
date.
respondent number 3 may be also protected.
You filed an application.
My lord, a date.
We fix a date. But file it. He is in urgency. We
Yes,
want to have your stand on record. List on, yes, when?
29, my lord, if possible.
Today is 21st. We'll have it on 1st of September.
Right.
1st of September, Monday.
Right.
And Mr. Parvez, if you want to file it.
Yes,
And get it tagged along with this.
Much obliged.
much of it.
May I please, your lordship?
Yes.
Lordship, yesterday, the lordship had directed me to address this court on
maintainability of my writ petition, your lordship, and accordingly, your lordship, I could place two judgments, your lordship.
Yes, please.
Okay, sound also.
You
But
don't
I'll
spare
just-
the entire judgment. Why are you wasting your pages and efforts?
Lordship, I
You
have
can
to-
cite it and you can give the,
Your lordship, so my case is based on these two judgments, your lord, on maintainability of my writ petition, your lordship. Lordship, let us first come to Kaushal Kishore judgment, your lordship. Lordship, in this judgment, your lordship, the constitutional bench, your lordship, on page 76, your lordship, actually, in this case, your lordship, the constitutional bench has discussed about the vertical and horizontal aspects of the fundamental rights, your lordship. And my case, your lordship, it comes upon that horizontal aspect, your lordship. And your lordship, from on para, my in this case, your lordship, five questions were formed, your lordship. That, and I am basing my submission on two grounds, your lordship. That is on page number 4, your lordship. Page number 4 of the judgment, your lordship. 5 questions, your lordship.
just a minute.
Page number 5, your lordship. Printed on both the sides, your lordship.
Page number?
5, your lordship.
Yes.
Lordship, I'll base my submission on question number 2 and question number 3. Question number 2 is, can a fundamental right under 19?
No, page number 5 where? Of which judgment?
Kaushal Kishore, your lordship.
Page number 5 is a brief, is paragraph 5.
No, lordship.
Brief.
This
brief.
side, your lordship. Both the pages. I printed on both the pages, your lordship. Same
Page
pages.
number 5 is containing paragraph 5.
4, lordship. Yes, 4, lordship.
Okay. Page number 4.
2 and 3, your lordship. Kindly, your lordship, I'll read out, your lordship. Can a fundamental right under Article 19 or 21 of Constitution of India can be claimed other than against the state or its instrumentaries? Third, your lordship, whether the state is under a duty to affirmatively protect the rights of a citizen under Article 21 of the Constitution of India, even against the threat to the liberty of a citizen by the acts or omissions of another citizen or private agency, your lordship. These two questions were framed, your lordship, and accordingly, your lordship, lordship, may kindly come to page 70, page 90, your lordship. Page 90, your lordship.
90.
Yes, your lordship. Para 71, your lordship. I'll read out, your lordship. Having taken an overview of the theoretical aspect of the verticality and horizontality and approach of the constitutional courts in other jurisdictions, let us now come back to the Indian context. Earlier, lordship, the various about the Irish constitution and South African, all those things were discussed. Now it has come to the Indian aspect, how our constitution is evolved in the horizontal aspect, your lordship. So part 3 of the Indian constitution, para 72, your lordship, begins with Article 12, which defines the expression of the state to include the government, the Parliament of India, and a government and legislature of each of the states and all other authorities within the territory of India under the control of Government of India. Then, your lordship, para 73, after defining the expression, the state in Article 12, and after declaring all laws inconsistent with or in derogation of the fundamental rights to be void under Article 13. No, part under aspect, part 3 of the Constitution proceeds to deal with the rights. There are some articles in part 3 where the mandate is directly to the state, and there are other articles, lordship, may kindly note it now. There are other articles where without injecting the state, certain rights are recognized, your lordship. Certain rights are recognized, your lordship, to be inherent either in citizens of the country or in persons, your lordship. And my case is based on that, your lordship. Now, your lordship, coming to the other side, on set of dichotomies between what is directed against the state and what is spelled out as inhering in every individual without reference to the state. The other dichotomy is between citizen and person. My case falls upon this, your citizens and persons, your lordship. And now, your lordship, there is a table, your lordship. If your lordship comes to row number 9, your lordship, that is on page number 93, your lordship. Your lordship, if you look at the top part, serial number, provisions containing the mandate to the state, provisions declaring the rights of the individuals without reference to the state. But Article 21 comes under that, you know. There is no rights of the individual without reference to a state. Article 21 protects my life, your lordship, and liberty of all citizens, and it is conferred on all the persons, your lordship. On
Is
that
your
aspect-
liberty at stake?
Yes, sir.
Your liberty is at stake.
Yes, yes, your lordship.
How?
I'll
No,
come
no,
up with-
let answer it. Your vehicle was on loan.
Yes,
Vehicle
yes.
has been taken away. How is
Yes.
your liberty at stake?
Your lordship, because your lordship may also kindly come to another. I have placed another judgment, your lordship.
Yes.
That is of the Patna High Court, your lordship.
Yes.
The state of the facts is same sets of facts, your lordship.
How much value will this judgment have in our court?
Entirely, your lordship.
Hmm?
Entirely, your lordship.
No, the Patna High Court, how much value will it have?
No, lordship, what my
Will it
case, your
have any
lordship-
presidential value?
No, your lordship, what my
So you have to make out a case. If your liberty is at stake, make out. How?
I'll make out, your lordship. In this case, your lordship, if you come to para 60, your lordship.
Of the Patna High Court?
Yes, your lordship. Which is on page 48, your lordship.
Yes.
Constitutional obligation not to act in violation of law.
Page 48.
Yes, your lordship. 47, your lordship. Sorry.
47. Yes.
Constitutional obligation not to act in violation of law. The banks and the finance companies who are contesting the matters, your lord. In this case, similarly was taken by the respondent, your lordship, that the case is not maintainable, your lordship. But the Honorable Patna High Court, your lordship, they proceed with this writ petition, your lordship. The banks and the financial companies who are contesting these matters are under constitutional obligation not to act in violation of law, your lordship. In my case, your lordship, I was not served any notice under SARFAESI Act. Neither a inventory has to be made, your lord. I was provided with nothing, your lordship. And that vehicle, your
What is your
lordship,
name?
D Das, your lordship.
Mr. Das, we are not even doubting the violation of your rights, but violation at the instance of whom? We are not saying that you are remedialess.
No,
We are only on the aspect to approach this court under 226. You have to
Yes,
make out a
lordship.
case.
Yes, yes,
It may
lordship.
not essentially be against the state or any other authority under 12.
Yeah.
That broad dilution is there, but you have to make out a case how your rights under Article 21 is
Yes,
violated.
your lordship. I'll substantiate on that part, your lord. If you
Yes.
come to my writ petition, your lordship,
Yes.
even your lordship, the agreement, your lordship, the agreement was not provided. Still that you are not provided.
The 21 violation. What is 21?
Right to life, your lordship.
Life and liberty.
And yes,
These are all commercial transactions. Something has not been done.
No.
Something has been done.
Lordship,
Enforce your
lordship,
right in the Supreme Court.
in Kaushal Kishore, your lordship, my right to livelihood is protected under, and it has been discussed here, your lordship.
Right to livelihood in a commercial transaction of
Yes,
this nature.
Lordship.
Can you
because-
show us?
Yes, because your lordship.
Can you show us? Where? In
Because your
Kaushal.
lordship, what my, in this case also, Patna High Court case also, your lordship, it has been held in one of the paras, your lordship, that.
Kindly show us.
Yes, your lordship, I'll show you.
Come straight to the point. We cannot have one case whole day.
Yes, your lordship, I'll come here, sir, 25. It's page number 25, your lordship. of
25.
Patna High Court, your lordship.
Yes.
In light of the aforementioned discussion, this court considered the fact of these cases. It is noticed that the petitioner are essentially complaining of violation of their fundamental rights
Yes.
to earn their livelihood with dignity, your lordship.
Hmm.
And my case is what, your lordship, I took a loan, and that loan was for the vehicle, your lordship. And running that vehicle, I am also running my family, your lordship, and also I'm paying my installments, your lordship. If, your lordship, they have illegally seized my vehicle, your lordship.
Were you paying all your installments on
Yes,
time? In time?
Yes, your lordship. I'm
Everything?
paying. Yes, your. That,
Everything?
yes, your lordship.
What about the last two installments?
We have paid, your lordship.
Let us see.
We have paid, your lordship.
Where are your statements?
Yes, your lordship. Annexure 1, your lordship. That is on. Annexure 1 from page 17, your lordship. May your lordship may kindly come to 19A, your lordship, my writ petition, your lordship.
Yes.
If you see, your lordship, the entire transaction, this is a statement of your lordship. 10th August 25, your lordship.
Yes.
I have paid your receipt number AX.
Let us see their impugned notice. Or impugned,
No notice was served.
impugned action. Let us see.
Yes, now,
Where is your statement?
Now subsequently, what has happened, your
Where is
lordship?
your statement?
My statements is on your lordship. That is on lordship page number para 4, your lordship. That is on page number 5, your lordship.
Please read.
Yes, sir. My read petition, your lordship.
There were some delays in payment of the loan.
Yes, your lordship. I'm
At the
accepting, your
same-
lord, but my term of the loan amount hasn't expired yet, your lordship.
Thereafter.
Thereafter, your lordship, what has happened, your lordship?
In spite of the hardships in operation, continue to pay the installments as per the.
Lordship, even I had missed my EMIs, your lordship, and penal charges were imposed upon me, your lordship. Later on, I paid the penal charges, your lordship. I'm not denying, your lordship, that I will pay you the entire money, but how can they possess the vehicle without following the in violation of the law, your lordship? Because there are laws laid down, your lordship. To
You
possess the vehicle.
enforce your right in the civil court.
Yeah, actually, yes, your lordship, I also have a right there, your lordship, but
What
it-
prevents you from going to the civil court?
because this is the because I think this court has the jurisdiction, your
No,
lordship, as per my limited
No,
understanding, your
no.
lordship.
What prevents you from approaching the civil court?
Because your lordship, my only thing was that, your lordship, to come before this court, your lordship, because I didn't have an agreement, your lordship. The lower court may have
These points cannot be raised in a civil court.
it can be raised, your lordship.
Then,
But my point is, your lordship, this court should take cognizance because if this is my case, your lordship, there are other cases
then
also.
we should all close all civil courts.
No, that is not.
No, that is your submission.
No,
This court has the
Why-
jurisdiction, we
why-
close all the civil courts.
Lordship,
We take up all the matters.
lordship, may kindly just
Any rights violated, we
No,
take up.
because why, your lordship? Because these financial banks, they are under an obligation, your lordship.
We cannot
Then-
open the door of, it will open a floodgate.
No,
We
no,
cannot-
lordship,
There has
because
to
your
be some
lordship,
self-imposed restriction.
lordship,
Our powers, no doubt are plenary in nature, but the
because your
self-imposed
lordship,
restrictions are
if you
there.
just go through the facts, your lord, after taking possession of my vehicle, your lordship, they are using it
And how
for
the
their own
state of
purpose.
Assam is a party, we not even know.
Because your lordship, how state of Assam under Article 21 in the Social Kishore judgment, it is also
Now, how in your case, state
yes,
of
your
Assam is a
lordship, how,
party?
how? Because your lordship, on 10/8/25, when I approached when it was on its way to Silchar, your lordship, on Neelam Bazar, your lordship, and accordingly we approached the concerned PS, your lordship, Silchar PS, your lordship, they straightly denied and refused, your lordship, to entertain.
That's a different cause of action.
Later on, your lordship,
Not entertaining a FIR.
yes, your lordship, same is the
Now,
case in
can,
the Patna High
in,
Court, your
in,
lordship.
with
Same
that
is the
cause,
case in the
with
Patna
that
High
cause of action, can you seek a relief against private persons?
Because your lordship, Kaushal Kikor explains my case, your lordship, that under Article 21, the state is also under, there is a responsibility to
This
protect
is
my
not
right, your lordship.
this is not a transaction between you and the state. Please try to understand.
I understand, your lordship.
Your transaction is a private one
Yes,
with
sir.
some Mahindra and Mahindra
Yes, your
Finance.
lordship. But in Patna High Court, your lordship,
Whether you have failed or not failed, those are all factual aspects.
lordship, if you just go to
You
the,
prove your case in the civil court, get the appropriate relief.
because your lord, my vehicle has been in possession, your lordship, and I immediately had to file this writ petition, your lordship. Because
Why this writ petition? Why not the
because, your
civil court? That is the
there is
question.
something happening in the state of Assam, your lordship, that needs to get noticed, your lordship, because without following, there are many cases, your lordship, but that has not come to the notice of this court, your lordship.
Are you espousing the cause of the general public in a writ petition?
No, I'm just.
Don't make those kind of submission, Mr. Das. We are not impressed with those kind of submission.
What
That something is going on in the state of Assam and you are the representative for the people.
No, that is
Then
not
don't
my
make
case,
those
your
kind of submission.
because
You are withholding a brief of your client.
what my case is, your lordship, because my rights, your lordship, my vehicle, I earn my livelihood from this case, your lordship. If this is not entertained, your lordship, I
We give you liberty to approach the civil court.
at least, your lordship, today they are going to sell the vehicle, your lordship. They have seized the vehicle without any, at least a direction from your lordship that,
You approach the civil court within a week. We'll protect you for a week.
yes, sir. That was my,
Third, your deeders,
yes, sir.
learned counsel for the petitioner. Full stop. Though this case was taken up for consideration on the strength of a mentioned memo yesterday, comma, the aspect of its maintainability had arisen, and therefore, on the request of the learned counsel, the same was adjourned and has been taken up for consideration today. Full stop. As per the facts projected, the petitioner had availed a vehicle loan in a wide an arrangement dated 5/8/2022, and the sanctioned amount was rupees 4,22,000. Please have your seat. The same was supposed to be repaid in 38 installments, which was to expire on 26/8/2026. Full stop. Without going into the details of the facts, it is the case of the petitioner that the EMIs were being paid timely. Full stop. However, due to an accident which the vehicle in question was involved with, there was some delay, which was, however, rectified. Full stop. For the said delay, some penal charges were sought to be imposed, and taking a cue from the same, the vehicle has been taken into custody by the respondent number 3 on 10/8/2025, which and a date has also been stipulated that on 21/8/2025, that is today, the vehicle would be sold. The petitioner has also alleged that an information was sought to be lodged in the Silchar Sadar PS as well as the Gorchuk PS, which, however, was not entertained. The Sri Das, the learned counsel, has submitted that the action of the respondent numbers 2 and 3 are expressly illegal and unreasonable, and therefore the relief prayed for are justified. On the aspect of the maintainability, the learned counsel has submitted that the right to life and livelihood is involved, and therefore the present petition under Article 226 would be maintainable. Paragraph 3. S.S. Roy, the learned state counsel, has, however, questioned the maintainability of this writ petition and has submitted that apart from the dispute being with a private entity, the same arises out of commercial transaction and can be raised in the appropriate civil court. Paragraph 3. Thus, the learned counsel has placed reliance upon the case of so-and-so of the Honorable Supreme Court and so-and-so. We'll give a brief details. The facts involved would, however, show that the transaction in question is a purely commercial transaction with private entities, namely the respondent number 2 and 3. Though this court at this stage would refrain from making any comments on the inter se rights and liabilities, the aspect of entertaining a writ petition with a dispute of this nature would not be the correct procedure. Though the mandate of Article 12 of the Constitution of India has been given a wider meaning so as to include even private entities, the nature of the dispute would have a relevant bearing in such a situation. In the instant case, as observed above, the dispute arises out of a commercial transaction. In view of the above, this court is of the opinion that the present approach to a writ court is not mandated, full stop. The writ petition is accordingly closed, full stop. At this stage, the learned counsel submits that some protection may be granted to him so that he can approach the civil court. Para? Taking the aforesaid facts and circumstances and also the submissions into consideration, it is provided that if the petitioner approaches the civil court within a period of 7 days from today, no coercive action, including selling of the vehicle in question, be taken by the respondents 2 and 3. Full stop. It is further clarified that the aforesaid embargo would be effective only for a week, and in the suit which may be filed, the petitioner can also pray for injunction, which will be considered by the learned court quickly in accordance with law. Sorry. Yes, Mr. Bhatti.
Yes, my lord. My lord, so far the excise matter is concerned, that has finally been decided by this honorable court. And now the question only relates to the levy of hate.
Department is not there, excise is there.
Excise
Yes.
is there, Lordship, with regard to the VAT component, Lordship, as per my instruction, Lordship, he has to make the payment as required under the Excise Act and rule. And Lordship, thereafter, whatever the dead stock or any non-feed stocks are declared by
Mr.
the
Chaudhary, you appear for whom?
for excise for Commissioner of Taxes. State
Commissioner
tax.
of Taxes. Yes, I think your feedback could be required,
Yes.
Mr. Borthakur.
Yeah.
Have you filed, nobody has filed affidavit?
Nobody has.
Oh, this is bad 2020 matter.
Our, my lord, submission was that, by virtue of this recent judgment of this honorable court, my lord, it held that regardless of whether the stock is sellable or not sellable, excise duty has to be paid, my lord.
No, we are ready to
That
pay.
has been considered. Now what remains, my lord, VAT, whether VAT has to be paid or not. My lord, Excise Act is silent about VAT. It does not say anything about VAT, my lord, which is why Finance Department was required, because they are the, my lord, enforcing agency of VAT. And for collection purposes, Excise Department collects both of them together, my lord, but the actual enforcement authority for VAT, my lord,
It
is
comes under the jurisdiction of the Finance
the
Department.
Finance Department.
Lordship, my instruction is that Excise Department will have to collect them, and whatever say unsellable.
Now, who will take the decision? The aspect of collection is not the issue.
Yes.
Aspect is on whose decision the collection would be done.
Now, my lord.
What is your instruction, Mr. Chaudhary?
Lordship, basically that it is completely under the domain of Excise Department. They will have to collect it, and whatever excess
But that
payment
will
is
not
made.
get in from the main respondent, Excise Department according. Now, Mr. Borthakur, if you do not have the jurisdiction to collect, you don't collect. You collect under what authority?
As per, it is, my lord, just the procedure that.
No.
Yes.
There has to be some basis
Yes.
which enables you or gives the power to you to collect.
Yes.
You show us the power. If you make out a case that it is on the instructions of the Finance Department says that it is not within our jurisdiction, then it may not be, there will be no basis to make the collection of VAT.
I'll seek clarification on this.
Okay. Mr. Bhatti, I think with this communication of Mr. Chaudhary, there is some confusion. Let the confusion be removed and we will try to resolve the issue. Heard Sri O.P. Bhatti, learned counsel for the petitioner. Also heard Sri B. Chaudhary, Learned Standing Council Finance Taxation Department, and Sri I. Borthakur, Learned Standing Council Excise Department. Para. Sri Chaudhary, the Learned Council, has placed on record written instructions dated 14/8/2025, as per which comma, it is the Excise Department which would take a call on the present dispute. Para. Sri Borthakur, the Learned Counsel for the Excise Department, accordingly seeks some time to have the clarification from the department. Para. List when?
Any day, my lord, as may be convenient.
After 2 weeks? List, this is of which year?
It is a very old one, 2020.
List after 2 weeks. Let a copy of the written instructions dated 14/8/2025 be served upon Sri Borthakur.
I have already given.
It was a photocopy at the book.
My lord, a particular date may.
You suggest a date, we'll fix a date.
Yes, my lord.
September.
No, second week September 9. Let it be, my lord, on 4th, my lord. 4th September. It is a Thursday.
On request list on 4th September. Yes, Mr. Saranya.
Lordship, my lord, the matter relates to my lord, the petition has been acquired for the purpose of national highway, my lord. Accordingly, my lord, as per law, they have paid the my lord land compensation and GIRAD also, but they have not paid the my lord Solicium of the GIRAD, my lord, 100% Solicium of the GIRAD.
Solicium not paid.
My lord. In respect of one has been shown to be paid, but
Who will pay? The KAC?
KEC, my lord.
Yes, madam.
Mr. J. Chutia is on his way.
Mr. Chutia is there.
Good wait. He's on his way.
We can have it after a while.
My lord,
Or is here? Yes, Mr. Chutia, you're not paying the solicium.
Solicium has been paid by them.
Has been paid.
Paid, my lord.
Have you stated that on affidavit?
We have filed a calculation also, my lord. Solicium has been paid, my lord.
My lord,
The
I have taken up-
calculation, my lord, all the calculation as per the, my lord, 2013 Act, my lord, calculation has been made. Solicium, 100% solicium, factor 1.2 and 12%, my lord, everything was calculated thereafter, my lord. And if the petitioner is aggrieved that, my lord, as per section 3G5, my lord, he can approach and we have furnished all the details, my lord.
This acquisition is under the National Highways Act.
National
Highway Act, my lord.
Then you have the avenue under the National Highways Act.
And if we
You
have
seek,
not-
you seek enhancement.
And we have already filed an individual award to the petitioner and submitted to the court also, my lord. Is all the annexes, my lord.
My lord, I have checked up, my lord. I have checked up, my lord, that only in respect of my lord, petition number 1 they have paid and soon to be paid, my lord, as per format. But other, my lord, there is no solution in respect of
My
that, my lord. It is
We have
reflected in their
annexed, my lord,
copies,
document.
my
The
lord.
petitioner should state, well.
In view of the documentary evidence before us,
My lord.
we'll allow you to approach the authority under the National Highways Act.
In our additional
Even
affidavit, my lord,
otherwise, these are
page
matters
190.
which will require a using of evidence. How can we?
My lord, in respect of if any dispute, my lord, regarding my lord value or what, there is no dispute. So this dispute is that they are supposed to pay, they have not paid.
Now they have said that.
That
they
is
have paid.
not to
My
go to the my lord arbitrator or a my
Now
lord.
they have said that they have paid.
My
Where
lord,
is
we
your
have
statement?
filed the affidavit, my lord, on 9/11/2023,
Yes.
enclosing all the documents, my lord, which is at page 190, my lord, annexure 1. How we have calculated it, my lord.
Let us see your statement, Mr. Chutia.
My lord,
Your statement in your
my lord,
affidavit.
page, my lord, lordship will look into, my lord. Our additional affidavit filed on in 2023, my lord,
Page.
page 184, my lord,
184.
paragraph 13.
Yes, please.
That the deponent has individually determined the compensation amount for acquiring the land of the petitioners in accordance with the provisions of the 2013 Act. The compensation amount for acquiring the lands mentioned in the notification published under Section 3D of the National Highway Act has already been deposited by NSDCL before the Kala, and the compensation amount has already been paid in respect of the land mentioned by the petitioner number 2242. The compensation Jirat has not yet accepted by the petition number 8 and 10. The compensation in respect of the petitioner number 1 could not be disbursed due to the complaint lodged by his uncle Sri Deuri Rongpi. The individual determination of compensation in respect of the petitioner enclosed herewith. We have enclosed all the documents, my lord. How it is page 190, my lord. Lordship will look into it, my lord.
Mr. Chotia, we have gone through your environment and Mr. Sarania has filed his reply,
My lord, I have
and
accepted
to
my-
paragraph 13, his reply is at page 231, paragraph 6. Mr. Sarania, this will come into the realm of factual disputes. You have said the sub-paragraph of paragraph 6.
My lord.
Petition number 1 is the legal error of Puri Rongpi, whose name particulars there. He has not received compensation because dispute is lying with Kala.
My lord.
Another plot of petition number 17.
Yes, my lord. Petitioner number 1, my lord.
How many petitioners are there?
My lord, here is my lord 42 total, my lord. But piece number 1, my lord, there is an uncle making a dispute, my lord. He also claiming that can be referred to principal civil court by the my lord Kala.
No, my lord.
I have no power.
My
They have to refer
My lord,
to
in
determine the dispute. Who is the actually?
In respect of the petitioner number 1, my lord, his uncle, my lord, lodged a complaint. We made an inquiry and we found in the records that the name of the Deuri Rongpi in the Sita was forced. And we have forwarded it to the forensic.
Now, what about the others?
Others, my lord, we have paid, my lord. Lordship will look into that. We have enclosed all the documents, my lord.
Then in my
He has made a specific statement that in respect of the which petitioner,
No,
solution has not
Mr.
included.
Mr. Sarania,
My lord.
this will be in the realm of disputed facts. He has said on documents, you have denied. Now, whom to believe now? We do not have the expertise.
My lord, in this respect, my lord, I pray for time, my lord, make a pending.
And
my lord,
otherwise, my
when-
lord,
We grant you liberty to close this.
if the petitioner
Will not
agreed,
say-
my lord,
will
then
not
we can
say
refer
that-
it to the district judge also, my lord, that in respect of the petitioners, that he has not received the solution that like that way also, my lord, or to the
Let us
arbitrator.
see. 3.
Section 3G5, my lord, first.
If the amount
3G5,
determined by
if
the
the amount-
competent authority under
Under-
subsection 1 or subsection 2 is not acceptable
By either of the parties,
the amount shall, on an application by either of the parties,
be
be
determined by
determined by the
arbitrator, my lord.
arbitrator to be arbitrated
If
already.
I
estimated.
wrongly calculate the solution also, then also he can approach the arbitrator.
When did you approach this court?
In 2021, my lord.
21. Is there any time limit for arbitrator?
My lord, Arbitration Act is applicable. That is the next provision, section 6. Subject to the Puja Act, these provisions of the Arbitration Act is applicable.
No, is there any time limit to approach the arbitrator?
My lord, there is a, my lord, appointment of the arbitrator, it also takes time for the
No,
last 2 years.
arbitrator has
Now has
already
not been appointed.
been appointed.
Now
There's
has,
a
it can be referred.
special secretary to the revenue
My lord,
department.
the petitioner can approach the arbitrator, my lord.
If another dispute is there, my lord, here, I am not raising now, I am raising the dispute, my lord, regarding my lord, wide of the road, my lord. That annex 10 of the petition, my lord, that has been under silence, my lord, here also, my lord. Regarding my lord, they have said, my lord, the road is, my lord, 50 by 50 earlier, prior to taking of the national highway. The national highway measurement is 75 by 70 both side, that means 150. So in fact, earlier it was 35, both side. So 15 feet roads, my lord, either side, that is 30, my lord, they are required to pay, my lord. That has been not assessed. There is a, my lord, that notification is under silence, my lord.
You can raise this.
My
You can
lord,
also raise this.
my lord.
That cannot be.
You can also raise this. That the compensation which has been paid to you is not adequate. It is not sufficient.
My lord,
And-
regarding
and
notification, my lord,
They have made an
government
incorrect
notification, my
assessment.
lord. Page, my lord, council notification, page 173, page annex 10, my lord.
173.
3, my lord.
Yes.
This is my under silence, my lord. The authority of Carbon married,
Yes, please.
page 173, Annexure 10.
Hmm.
The authority of Carbon Autonomous Council Dispu is pleased to notify the henceforth the roadside reservation of land in respect of National Highway 29 under the jurisdiction of Karbi Anglong Council will be 50 feet on either side of the road from the entire line of the existing road, National Highway from Parapua to
Lahorijan.
Lahorijan. So earlier, my lord, it was, my lord, in general, my lord, as per Assam Land and Revenue, my lord, rules, my lord, that is 35 each side, my lord. When the land patta have been issued to us, my lord, that has been shown as a 35, we cannot claim either side or the middle of the road. Now they are saying we're 50, my lord, without any, my lord, provision of law, my lord.
What do you
Without
say,
any
Mr.
basis.
Sutia, on
My
this?
lord, we have, my lord, Lordship, look in the word, will be 50 feet from either side of the road from the center line.
Center.
Center line. If it is the center line, that our calculation, they have to return 50 feet land, my lord. So it is only for the benefit of the petitioners, my lord. As per my lord, clause terms and condition of the lease, they are not entitled to compensation for 35 feet from the side of the road, my lord. That is a condition of the lease, my lord. That is a condition of the lease is 35 feet from the side of the road, my lord. And as per the land revenue regulation, 50 feet, 15 feet from the side of the road, my lord. And it is 50 feet from the, my lord, center of the, my lord, road, my lord.
So what is your contention, Mr. Samaria?
My lord.
My lord.
That, see, this is the, what is the meaning of this notification 23/3/2020? Henceforth, the roadside reservation
My lord.
of land would be 50 feet on either side of the road from the center line.
Center line.
Suppose this is a road center, from the center, 50 feet this side, 50 feet this side. Okay.
100 feet.
Huh? What is your contention?
So my contention is, my lordship may come to my lord, one patta, my lord. Lordship, page 36, my lord. One of the patta.
What is the width of the road, Mr. Chutia?
My
Road.
lord, NSLECL, my lord, in some other cases have filed the affidavit.
Mr.
my
Bora,
lord.
what is the width of the road normally?
In the RK Talukdar filed affidavit in some cases, the notification, my lord, in other cases. my lord.
What is, how much is the width?
My lord, it is, probably it is 35 feet, my lord. It is only for, my lord, I can only submit it. It is only for the benefit of the petitioner.
No, we're just trying to make a rough calculation.
My lord,
If it is 35 feet,
my lord.
that means
That road.
17, let us see, let us hold on the higher side, 18 feet. Then 50 minus 18.
17 feet. This
32, 32.
My lord, from the center, my lord. And my lord.
There is no
and
violation, there will be
subsequently, my
no
lord,
violation.
My lord,
No, my
if-
lord.
my lord, if, my lord, may I submit, my lord?
Just a minute, Mr.
Subsequently, my
Chutia,
lord.
just a minute. We'll clear with Mr.
My lord,
So-
see, my lord, as per the patta, my lord, the patta has been issued.
Yes.
We have to leave 35 from the center of the, my lord,
Not side of the road.
side of the road. So from the center, 35.
Now here it is 32 only.
My lord,
It will be 32.
35, my lord.
No, you have to leave 32, but here by this notification,
My
you
lord,
have to leave even less, 32 around.
my lord.
It will be less than 35. Because 50 from the center of the road. The road, a rough calculation, it says about 35 feet.
My
From
lord.
the side
So
of
even
the,
if you hold it to be a 36 feet, then half will be 18 and 50 minus 18.
and now we have already withdrawn it also, my lord.
This notification has already been withdrawn.
Withdrawn, my lord.
Oh, my lord, that's.
My lord, that is only for,
Where have you stated?
my lord, we have not stated, my
But
lord.
have you got the instruction?
My lord,
My lord,
in
and
some, not in this particular case, in some other cases, my lord. Well, I have the instruction.
But otherwise also it's not
But it is
causing,
not, my lord.
it's
So
not
I have,
causing
it is
prejudice to
only
you.
for the benefit of the, my lord, petitioner.
It's
my
not
lord,
causing prejudice to you.
Not prejudice to it. It is my,
no, but if I understand correctly, my lord, the 35 and 50 feet, my lord.
Potter condition
No,
is 35 feet from the side of the road. It is from
Now
center of the road.
this 50 feet from the center of the road.
Center of the road.
Road is itself around 35
5
feet.
feet.
So around 17 to 18 feet will already be gone.
My
So
lord.
your clearance will be, in fact, you are well protected.
Well, madam, my lord, maybe fix on 28. Another matter is similar, my lord. The notification has been selected.
20?
28, my lord.
We can finish off this matter.
my lord.
We grant you liberty under 3G5. And this we consider, and we also record his statement that this has been withdrawn.
My lord. I can get.
Okay, we'll have it on Wednesday next.
My lord.
Take instructions.
My
We'll finish this.
I can, my lord.
Okay, heard Sri M. Sarani, a learned counsel for the petition, has also heard Sri J. Chutia, a learned standing counsel KAC. Sri Bora, D. Bora, learned for,
On behalf of Mrs. R. Bora. for
on behalf of Mrs. R. Bora for NHIDCL.
1 and 7.
Oh, NHIDCL. And Sri N. Goswami, learned state counsel. Para? Sri Chutia, the learned standing counsel, has submitted that the solution has been paid to each of the petitioners, which was the primary grievance. And in this regard, he has drawn the attention of this court to the affidavits filed by the council. Full stop. As regards the aforesaid aspect has, however, not been endorsed by Sri Saranya, and he has by submitting that there are disputes in this regard. Para? As regards the challenge to the notification dated 23/3/2020, the learned standing counsel has submitted that he has oral instructions that the notification has been withdrawn. He, however, submits that in any case, the said notification would not cause any prejudice to the petitioners, as there would be no violation of the conditions imposed in the lease.
My lord.
Lease in favor of the petitioners regarding clearance of 35 feet
On the
of
side of the
land
road.
from this side of the road. Para? Sri Saranya, the learned counsel for the petitioners, prays for some time to obtain instructions. Para? List. On the first aspect, the learned standing counsel has submitted that under the National Highways Act 1956, adequate provisions are there to raise a dispute of the present nature if the grievance still exists. Wednesday, huh?
My lord.
Wednesday, boli kolo na? Nahi koa na? List on Wednesday. Wednesday will try to dispose
My
this.
lord.
All my lord.
And that notification, my lord, if I get it, my lord, that other, my lord, wide of the road, my lord, yeah, and highway, national highway, I can produce it.
And regarding the withdrawal part also.
Without part, my lord, I have, just now I can get it.
Yes, for the last order, this morning also I received an affidavit. I filed an affidavit.
Okay.
This morning.
What is the matter?
It's shifting the household of the petitioner from one word to another word.
Okay, would
They have
like,
filed their affidavit.
okay, would like to argue.
No, Lordship.
They want to file
a
reply.
Joined affidavit, okay. Heard Sri BP Bora, learned counsel for the petitioner, as well as Sri S. Datta, learned standing counsel.
Well, in this case, I am appearing on behalf of Mr. K. Kaur as he is appearing as additional advocate general.
Okay. It is for the Panchayat, no.
Well, this is also there. That is why he is
Okay.
appearing on behalf.
Well, as Datta, who appears on behalf of Sri K. Kaur, learned AAG, full stop.
For a state.
Para. Sri Datta has informed this court that the affidavit in opposition has been filed this morning. Para. Sri Bora, the learned counsel for the petitioner, prays for and is granted 2 weeks time to file rejoinder affidavit, list after 2 weeks. Deeply.
Highly obliged.
What is your name? Janata Das.
There are other petitioners also. Good. Obliged.
Yes.
My lord, we have filed an affidavit stating everything. Only if your lordship requests him to take a copy, he refused to take a copy. I don't know why he doesn't want
Just
to.
before lordship, 15 minutes before call me lordship. I am in court, after going to court, I will receive it.
My lord,
Just
after
before
going to
15
the,
minutes, lordship.
going court, he will receive it. So,
You should receive it, Mr.
But-
Kolita. Receive it and express your
Yes.
predicament before the court. You should not refuse to
Yes, sir.
receive.
No, no, he just
We'll
told me.
take care of the fact that whether you are served beforehand.
my
But
lord,
you should not, never refuse.
No,
You
no,
give the time that I have refused at 12 o'clock. I refuse.
normally it's served to my clerk lordship. And normally
That
my
is,
clerk
no, you
is-
should receive. It's not requirement. There is no requirement.
Lordship.
my
If
lord,
you want some time, we can grant you some time to go
Not
through it.
necessary, not necessary.
Huh?
Request is already in before the honorable court lordship.
Okay. Okay.
my submission before your lordship.
What is the matter?
Matter is that, my lord, we are the tenants given to us by the Kabastan committee.
Oh, that matter, those matter, yes.
My lord, I think, my lord, Justice, my lord, sorry, Mr. Kane Chaudhary will be coming because he's lordship.
My CA is engaged before some other, after some time, your lordship. He is engaged before court number 7, your lord.
What to do?
Can it be given some other date, my lord? Then, my lord, he has also got the copy. We have served to the.
What have you brought here in this
My lord,
petition?
we have brought into here, my lord, this is in violation to Article 26. My lord, there the duty cast on the government because the learned coordinate.
No, unless and until it is declared as walk-off property.
My lord, that is walk up by user. It was from earlier sales, and I have given categorically got some judgment.
Yes, who is for the government? On the last occasion, who was there? Mr. Gogol was there.
But Pujari was jealous.
Borpujar was there. Yes.
We have served copy.
Yes, Mr. Madam. Okay, we'll have with some other day, Mr. Chaudhary come. We'll press out this matter.
Well,
This should not continue.
my lord, we have given copy. I think all without serving them copy, we have given to the office.
Okay. Whatever exchange is required, you do it.
Well,
But we'll have on when next Thursday.
Thanks, lordship.
Next Thursday,
my lord, next Thursday is 28.
28th.
Lordship, some
Okay.
other,
Huh?
some other day, your lordship.
Don't delay it.
Especially
There's an interim order. We don't want.
My lord, fourth,
There also for respect number 5, first same side of me. He is also opposing.
fourth
28 lordship.
is a Thursday, my lord.
4th September,
Well-
Mr. The Kolita, 4th September.
Lordship.
Okay, but Revenue Department, we want the person would be arguing for Revenue Department. Okay. Sri P.K. Roy Chaudhary, Learned Counsel for the petitioner has submitted that an additional affidavit
My lord,
has been filed, which has been brought on record. Para? A prayer for adjournment has been made on behalf of Sri K. N. Chaudhary, Learned Senior Counsel, who appears for the respond number 5.
5.
Sri J. Kolita, Learned Counsel for the respond number
5, 6 to 12.
5 also.
Lordship.
He is also
Because
number 5.
Lordship. Dispute is jealous. So lordship, I will satisfy
We
you.
cannot
lordship.
allow two counsel for the same.
Because lordship,
You will record for 6 to 12.
that may be already my name is there for 6 to 7, 12.
5 is also you there.
Yes, lordship. I filed my affidavit also. They have not yet filed their affidavit also.
I filed my wakalatnama.
Only Akalatnama lordship, no affidavit till date.
No, see, we'll maintain some standard. We'll
Yes.
not allow two counsel
Lordship.
to
I will satisfy the honorable
either
court whether or
Mr.
not they
Chaudhary or
have-
Mr. Kolita.
Yes. That aspect-
And if there is a dispute, kindly resolve your dispute outside the court. Don't make it an embarrassing position in the
Yes.
court.
I will satisfy the court whether or not they have.
Sri
been
J.
opposed.
Kolita, Learned Counsel, has submitted that he was authorized to appear on behalf of respondent number 5
Lordship.
to
12, 6, 7, 8, 9, 12,
5 to 12.
Lordship.
5, 6, 7,
8,
8,
9,
9 and 12.
11, 12.
6 to 12.
6 to
6 to 12. And has also filed the Wakalatnama as well as affidavit.
of course.
Full stop. Para? Para na. He has also, full stop. He has also submitted urgency as an interim order is operating. On 4th
September.
4th September.
Millard, actually,
But,
there is an aspect of Waqf Act also, Millard.
Mr. Chaudhary, before that,
Yes.
there should not be any confusion. Mr. Kolita
Yes,
says
madam.
that he is authorized to appear, he has filed Wakalatnama for, even for respondent number 5.
He.
We don't want two counsel.
Anyway, Millard, therefore, let us inquire, Millard.
Yes,
They-
please sort
yes,
it out.
Yes, yes.
See, if a senior counsel is there, there is no requirement to hear some, but if he asserts that he is the counsel, then there will be some embarrassment.
Only dispute that
Oh.
we are Lordship opposing that plea and they are.
And there appears to be some difference of opinion.
Respondent
Yes.
number.
Yes, yes.
Five. And then that I don't know, my lord, ask my instructing counsel, my lord.
And he has asserted that he has even filed the affidavit, which later on.
Yes, no, basis of the trial court order was.
Yeah.
No, my lord, that
List,
will-
list on fourth.
Yes.
Fourth.
Interim order to continue.
Interim order passed earlier to continue till the next date of business.
In the meantime, Lordship, if necessary, I will try to respond to the.
The respondent numbers 5 to 12 may file a response to the additional affidavit if so advised.
Lords.
Yes, where are you, Mr. Borpadari? You are the main person.
I was stuck up in court one.
Fourth. Fourth. Yes, 16 and 17.
Yesterday I submit one that instruction law. I also sub the copy to my.
Yes.
Because the same resolution was adopted in the year 2021. You also kindly see the affidavit filed by the corporation.
Now, this is a new resolution.
The new resolution. my lord.
Yes.
Earlier, my lord, it was not been
Yes,
resolved.
this is within
No, that
time-
is why we have given you
Yes,
time.
my lord, within time frame, my lord.
Okay. Third. Who's appearing in two cases?
Yes, my lord.
Two cases. My lord, the both the cases, my learned friend has been.
16 and 17.
Lordship.
And now Mr. Ahmed is also appearing.
Yes, my lord.
I am
And
appearing in
Khan-
17 lordship.
So Khan, you are appearing in 17. Hard Sri, FKR Ahmed, Leonard Council in WPC so and Sri NI Khan, Leonard Council for the petitioner, with the petitioner in WPC is next to, huh? Para? Also heard Sri J. Hendrik Leonard State Council. And Sri S. Das, Leonard Standing Council, AIDC. Para? Is revenue a party here?
Lordship, pardon. Respond number.
Yes, circle officer.
Revenue is not a party.
Revenue notified.
Okay. Okay. The grievance of the petitioners in these two cases in brief is in connection is with the allegation of violation of the right to fair compensation and transparency in Land Acquisition So-and-so Act 2013. Full stop. It is the case of the petitioners that in spite of acquisition of land, no adequate compensation has been paid to them. Full stop. Para. When this matter had come up for consideration yesterday, comma, where is that? My notes?
My lord, yesterday I was.
What, where did you know that? I think it we had given that back. Where is it?
There is question. Ali, there is inquiry.
No, it is there. What is that? It's there. It's there, it's there. What is it? That is a record of recovery question. Put made part of the records. Made part of the records. Put. You cannot know. It doesn't make sense. No more side, yesterday, when the matter was taken up for consideration, Sri Hendrik had placed before the court a minutes of meeting as per which the grievances of the petitioners appear to have been redressed. Full stop. On the aforesaid contention, time was granted to the learned counsel for the petitioners to seek instructions. Para? Both the learned counsel for the petitioners do have submitted that in principle the grievance appear to have been redressed, comma, such decisions were also taken earlier, which did not fructify.
Yeah, 2012, 2021.
fructify in payment of any compensation. And therefore they have expressed an apprehension. Be that as it may, on perusal of the minutes of meeting held on 8/8/2025, whereby there are clear resolutions that the recommendation for payment for allotment of land to the petitioners have been taken, comma, this court is of the opinion that there is no requirement to continue with these writ petitions, full stop. Both the writ petitions accordingly stands closed. Full stop. However, it is observed that the resolutions numbers 4 and 5 be implemented expeditiously. And in any case, and preferably within an outer limit of 3 months from today. A resolution to আমি কোড করে যাম, হ্যাঁ 4 and 5 ওটার উপর দিন, হ্যাঁ এটা ইয়াতে মতো টাইপ মারিব। For ready reference, the resolutions number 4 and 5 are extracted here in below.
At least my lord, for last 4 years, they utilize my land, my lord. They should pay some compensation at least for that, my lord.
Yes. Yes, next. Right. Up to 15, no? 15, right.
The Lordship's last query, we have got instructions here of this. I have. And as per the notifications, it falls under Lordship in the last date that I have given to your Lordship in category number 3 and 6, your Lordship. Now, the mail that I have received, annexure 1 may kindly be perused.
Where is that notification gazette last time you had produced before this court?
It is with the record, not sure. It is also tagged with this document I have produced before your Lordship. Annexure 2, your Lordship.
Okay, yes, we have got. Any university, it's not an university, any college, whether or not affiliated to the university, does not fall. Any school, whether or not recognized
Either public or private, your Lordship.
by the central or state government. You say that it falls under this.
Yes.
Is it a school
Is it a school, your Lordship? May kindly peruse annexure 1.
of?
My document produced. It is an assessment letter dated 10/6/1999, where the school establishment was of 1/1/1993, and up to 10/5/1999, they have 23 numbers of teachers. And they have, on the last part of the letter, a code was also provided to the concerned establishment for further compliance as per the Act. Now, your Lordship, annexure 3, we have annexed some photographs, your Lordship.
Yes.
It has been shown as a school, your Lordship. And most interestingly, your Lordship, their own letterpad, your Lordship, as annexure 3, page 11, I have marked.
Yes.
They themselves have stated as an English medium school, your Lordship. It is not a tuition center or tuition private, something like that.
Yes, Mr. Boro.
Having an UDICE code also, your Lordship.
Huh?
Page 13, your lordship.
What is that?
They have an UDICE code, unified. Having an UDICE code, your lordship, number
What is you
one.
guys? Okay, okay.
Page 13.
Or page 13.
And annexure 5 is also there for entire details of the school regarding. Now, this is an identification given by the Ministry of Education India.
It is not a tuition center.
It's not a
No,
tuition.
my lord, thing is that I have stated in para 2, it's a private teaching center, my lord. And the main issue, your lordship, is on the provision of section 1, subsection 3 and B, my lord, of the Employees Provident Fund.
And the most interestingly, your lordship, annexure A that has been annexed in the writ petition, page 26, the general power of attorney, they themselves have admitted this is an English medium school, your lordship.
Page?
Page 26 of the writ petition, annexure A, the general power of attorney. That day, actually, I missed out, your lordship. I'm extremely sorry for that.
No, this is.
Proprietor of Jyoti Vidyapit and English medium school.
Yes. These are statutory liabilities you cannot bear.
No, my lord, thing is this, my lord, that question has to be determined under this section 1, subsection 3B
of
the Employees Provident Fund. That they have not done. That is our grievance, my lord.
One?
Assessment.
Section 1, subsection 3B.
Yes. But
That
you
is-
had 23 numbers of.
Then in that case, section 2(5) is there, your lordship. If an establishment to which this act applies shall continue to be governed by the and the number of persons employed therein, if falls down, that in that time also this act is applicable.
You are
I-
referring to, we are referring to
Section 2(5),
2.5.
yes, continues to be governed by this act,
No,
notwithstanding.
no, that's not 2.5, 1.5.
Oh, sorry, 1(5), your lord. Oh, 1(5), sorry, your lordship.
My lord, this nature of employment is the prime consideration in order to attract the provision of subsection 1, that which Hariharan case of Supreme Court says. Merely
That is
because
okay, but yours is not a private tuition center, it's a school.
Either
it's
The
a
notification
school, my
is-
lord, run with a honorarium paid to them, and it is closed, my lord. Because
But,
this,
but the time when it was running, you are under an obligation, legal obligation under this Provident Funds Act.
legal
and rules.
obligation, my lord, that they have to ascertain, my lord, whether only 20 employees definition, my lord. That is the thing, my lord, that
Any establishment can.
let me, my lord, bring this back, my lord. I'll, lordship, section 1, subsection 3B,
Yes.
to any other establishment employing 20 or more person or class of such establishment, which the central government may by notification in the official gazette specify in this behalf. Now, in this, my lord, this Provision Fund Act, my lord, this section has been, my lord, literally, my lord, interpreted in the Hariharan case. That is the thing, my lord.
Yes.
Your lordship will come.
Madam, have your seat, we'll come to you.
Nature of employment, that is the thing, my lord. Because that scheme has to be under the conformity with the act, my lord. So, your lordship, may I refer to, which they have not determined till now, my lord. Paragraph 6 of that Hariharan judgment, your.
Yes.
6 and 8 and 9, my lord. May I read your? Para 6. The narrow questions which directly arises for our consideration is whether clause B of subsection 3 of section 1, when it speaks of the establishment employing 20 or more person, means that the person so employed may be employed by the establishment for any purpose whatsoever and for however short a duration, or that the employment must be for some minimum period in the establishment. The language used in the clause does not give any clear indication. We have therefore to constitute this word
In the light of the legislative scheme, the object and purpose of enacting this clause and the ultimate effect of adopting one or the other construction, the relevant section of the statute have already been reproduced. Now, paragraph 7. Section 16, which has already been set out in extenso, seems to us to throw considerable light on the point raised. It may be recalled that this section excludes from the applicability of the Act establishment belonging to government and to local authorities and infant establishments. It is therefore obvious that this Act is intended to apply only where an establishment has attained, this is important, sufficient financial stability and is prosperous enough to be able to afford regular contribution provided by the Act. Contribution by the employer is an essential part of the statutory scheme for effectuating the object of inducing the workman to save some time, save something regularly. Establishment therefore must possess stable financial stable capacity to bear the burden of regular contribution to the fund under the Act. In this connection, it may be recalled that by virtue of Section 1, subsection 5, an establishment to which the Act is applied continues to be governed by the Act, notwithstanding that the number of persons employed by it at any time falls below the required number. This liability to be governed by the Act ceases only if the terms of the proviso to Section 1(5) are complied with. The financial capacity of an establishment to bear the burden must therefore have some semblance of a reasonably long-term stability, Your Lordship. In other words, the employment of requisite number of persons must be dictated by the normal regular requirements of an establishment, reflecting its financial capacity and stability. It therefore follows from this that the number of persons to be considered to have been employed by an establishment for that purpose of this Act has to be determined, Your Lordship. That is the thing. By taking into account the general requirements of the establishment for its regular work, we should also have a commercial nexus with its general financial capacity and stability. This seems to us to be the correct approach under the statutory scheme.
Mr. Barua, under what context these observations were made? What was the issue before
My
this?
Lord, I'm coming, my Lord, paragraph 9, my Lord.
Yes.
Yeah.
Have you read the facts?
Yes, sir.
What was the facts? What were the facts?
Facts was, my Lord, regarding, my Lord, the employment of person for any purpose, for a duration.
It was for a temporary duration.
Yes.
That because of failure of rains from June to September, some persons were utilized for
Yes.
supplying water.
Yes, yes.
And according to the corporation, they were held to be regular employment, which the High Court did not agree.
Yes.
And the Supreme Court has agreed with the High Court. But here, teachers in an establishment of a school, your basic portrayal of facts is incorrect. You said it is a tuition center.
No, no, my Lord, I have stated, my Lord, possibly from in paragraph, is a private teaching center, my Lord. Paragraph.
Teaching center, you have
Yes.
not used the expression school. What prevents you from teaching center, which gives a different connotation?
Ship, I have given another
May I-
set of.
Please have your seat.
Madam, may I
Welcome.
complete this paragraph 9?
We have read the entire thing.
The section 1(3)(b), my Lord, paragraph 9, my Lord, just, my Lord, one.
We have read this.
Okay. my Lord.
Read this.
So your Lordship will kindly come to my paragraph number 19, your Lordship,
Yes.
of the writ petition.
Hmm.
Why we have to be repeatedly come here, my Lord, before this court, my Lord.
Hmm.
Second time, my Lord. This is the second writ petition. Paragraph 19, your Lordship will come. Because after 15 years, they have issued this demand notice, your Lordship. Paragraph 19. Paragraph 18 and 19, my Lord, I'll read.
Paragraph 18, yes.
18 and 19, that a petitioner states that recovery officer took the matter for hearing on 10/7/2015, where on behalf of the teaching center, may I read page 18, Your Lordship?
Yes.
Page 18 of the resolution. The petitioner states that recovery officer took the matter for hearing on 10/7/2015, where on behalf
Mr.
of
Boru, from where do you borrow this expression teaching center?
simply, my lord, there was another case I mixed up, but in my,
No, your document says.
oh, my lord, yes, this teaching center, my lord,
It's an English
because,
medium school.
because there were no appointment, no salary paid, it was no appointment letter, my lord. They cannot show
With
that.
this kind of a school, with this building, you are not paying any salaries. We believe you.
No, my lord, the thing is that the lady was on a honorarium just for, she's a ideal housewife running the school.
And
for
those
the-
persons who have been imparting their, discharging their duties?
They are no more, my lord.
No, at that time, English medium school, they'll teach for free.
Yes,
Exploitation.
honorarium was paid, man, minimum amount of honorarium.
That will not help you.
Your lordship,
You
kindly
cannot
ask.
escape the liability. We thought that it was a tuition center. You have not projected your facts properly.
Well, actually, it was in 2015, my senior was there, my lord.
No,
Anyhow, my lord. May I read your paragraph 18 and 19, my lord?
18 and 19,
Yes.
please read.
That the petitioner states the recovery officer took the matter for hearing on 10/7/2015, where on behalf of teaching center, the petitioner represented and thereafter, right, order dated 10/7/2015, the recovery officer, without considering the contention made in the writ petition, earlier writ petition, though directed by this honorable court, right, order dated 18.
That part you have already
Yes.
placed before us.
Yes.
That is a
Then-
misnomer.
yes.
He has dismissed the writ petition.
No, my lord, he has not decided the jurisdiction, whether it is an establishment which come under the scheme, that will give them the demand notice under section A. That I will come to section 7A, my lord. Paragraph 19, your lordship, kindly. That the petitioner states that though it was specially raised in the writ petition, that all the existed employees on April 1999 were engaged purely temporary, part-time basis, that is engaged for 2 or 3 classes only, so that they can also leave their jobs at any time from the petitioner teaching center when they get any good next phase, any good opportunity at any other place. It was incumbent on the recovery officer to decide as to whether the nature of employment attracts the provision.
Where have you described your school?
My lord.
Where have you described? Let us see. What kind of classes?
Paragraph 2, your lordship.
Paragraph 2,
Yes.
yes. Nursery to KG,
Yes.
1 to 4. Oh,
Paragraph 2, your lordship.
yes.
And she started this school, my lord, on 1/1/1993 from the classes of pre-nursery to KG playgroup and classes 1 to 4. The classes of pre-nursery to KG playgroup were allowed to attend the aforesaid private teaching center without paying any monthly fee. There is nothing, your lordship, no record of paying. Yes, your lordship. As there were no sufficient students and collection of monthly fees from the students of class 1 to 4, the proprietor engaged some teaching staff initially by paying a minimum amount of honorarium to them.
See the photographs you have not enclosed. Yes, madam, do you have a copy of this?
Lordship? Yeah.
Kindly show it to your friend.
He has given money. That is their own land money. As well.
See the building.
Yes.
Is it a residential property or is it a school?
Lordship, as today I have not produced, your lordship, there is an annexure force, but the school have a managing committee because and letter has been communicated, that is annexure 4, page 12 of my today's document, your lordship.
12.
Page number 12. They themselves stated that, and this letter has been given by the chairman managing committee. So a school only have a managing committee. can have a managing committee, Your Lordship. Moreover, another document dated, another set of document I have given Your Lordship.
These are not on records.
At that time when the affidavit was filed, these were not placed before Your Lordship.
Madam, put this on record.
Then I may be allowed to file a,
Put this on record.
yeah.
Here, you have also stated that this, by this managing committee letter, they have talked about annual examination.
Yes. And they have themselves agreed to carry on this, to means abide by the
This is
fee.
a matter, 14, we should not. What was your earlier affidavit, madam?
That affidavit, they have, the earlier set of, earlier advocates.
Hartspree B. Borwal Leonard Counsel for the petitioner. Also heard Ms. S. Dasgupta, Leonard Counsel for the Employees Provident Fund Organization. Full stop. When this matter was taken up yesterday, that is 19, not yesterday, 19, yes, taken up on 19/8/2025. You were not earlier there. Are you,
Lordship,
where is it?
Advocate Dilip Dey was there.
You came later or what?
I have been empaneled in the month of April, Your Lordship.
Okay. Ms. Dasgupta, the Learned Council has submitted that she has been recently engaged and had sought for some time to obtain further instructions. Para. Today, the Learned Council for the, today Ms. Dasgupta has, the Learned Council has placed before this court certain written instructions along with documents to support her case that the present challenge is not even maintainable. As the documents are not on record by way of an affidavit, this court directs the
All the respondents.
to file an affidavit and put on record the relevant instructions and documents so as to give a fair opportunity to the petitioner. Since this matter is long pending, let such affidavit be filed within a period of
1 week.
within a period of 10 days from today. Matter will be listed after 2 weeks
Much obliged.
for hearing.
Well, earlier interim order.
Interim order passed earlier to continue till the next date of listing.
Of life.
Mr. Goswami?
May it please the lordship.
By the way, why is Mr. Chaudhary in this court? What's the matter?
In some other court, but
He's
he
enjoying-
feels happier in this
Enjoying the proceedings.
atmosphere.
We are thinking that he will be appearing in some matters. Matters are being exhausted.
Even I thought that way, I asked him, he said no.
We were looking into the list, which matter is he appearing?
He appears to be more comfortable in.
Thank God.
Here Goswami is also joined the bar.
Okay,
He's here.
yes, very good to see you. Okay. But Mr. B.D. Goswami has not become old.
Really, Manu?
He never,
You are, Mr.
He's
Goswami is evergreen.
I don't know, but
we know him as a mountaineer. He used to go mountain climbing.
Yes, what is this about?
this is, my lord, against some eviction notices that were sent, given to the group of petitioners, my lord. And that is one issue. And the number two is, my lord, these people have suffered from flood, my lord, particularly from a river called Velengi in Borbeta district, and which displaced them, my lord, to their present place where their houses. That is called Bhatkusi Reserve. It's a grazing reserve land, man. And
You're in a reserve land, grazing reserve.
Grazing reserve.
That's a difficulty.
There is a difficulty, and but they, my lord, their ground is this, my lord. The government of Assam had introduced a scheme, my lord, for people like them who suffered flood and all those disasters, and they also created notices, subdivision level, district level, etc. My lord. And they said that they have been left out from consideration of that particular scheme. That scheme I have annexed at page 34, annexer C.
Yes, what do you say, Mr.
My lord, that scheme, my lord, already
That has gone.
gone, lordship. 2023, lordship.
But anyway, the notices, I would like to.
No, against reserve, we perhaps will not be able to grant you any relief. Vizier land, Jakpal.
Jakpal Singh. Jakpal Singh is very correct, my lord. But then, my lord, as the.
And scheme of 2015 has gone.
It's gone, lordships, on.
A1, A2, A3, my lord.
You apply to the government, they will consider it in
Yes,
accordance
my
with law.
That is what, my lord. These
But-
notices were, my lord, to vacate the land.
That has to be, that we cannot.
At least we'll apply to them, to the authority, my lord, and they will consider, my.
Heard Sri B.D. Goswami, learned counsel for the petitioners. Also heard Sri J. Hendik, learned state counsel.
May I also place a similar order, man?
No,
Similarly,
we are not.
similarly,
putting,
similarly, please, man.
No, we're passing the order, not record. I also heard Sri J. Hendik, learned
About
state
2, 3 and
counsel,
4.
and Miss G. Hazarika, learned standing counsel, Revenue Department, Para. As per the facts projected, the petitioners who are 36 in numbers, please have your seat, Mr. Goswami. Numbers are flood affected persons. Full stop. It is contended that the petitioners were affected by the flood of river Helengi in the district of Borpeta, forcing them to move to Bhatkuchi Reserve of Jonia Mouza under Bagbor Circle in the district of Borpeta.
Bagbor Revenue Circle.
Bagbor
Revenue Circle.
Revenue Circle. The petitioners also stake claim on a scheme named Chief Minister's Special Scheme for Rehabilitation in Assam, inverted, which was notified by notification dated 12/3/2015, whereby homeless people like the petitioners were sought to be rehabilitated. Full stop. It is submitted that though pursuant to the said scheme, some survey were made and recommendations were also made for 384 number of families, the petitioners were not given any benefit of the said survey. Full stop. Accordingly, the present petition has been filed with the following relief. Para relief, huh? Sri Goswami, the learned counsel, has submitted that they are entitled to a fair and equal treatment.
May I just point out one thing? They were, instead of that, man, they were issued the notices at Annexure G series.
No, yes, wait. They are entitled to a fair and equal treatment by giving benefit under the scheme. On the other hand, the petitioners have been served with
Annexure G,
with notices dated 3/1/2017, directive informing that they were encroaching land and they were directed to vacate the same. Full stop. It is submitted that without the petitioners being considered under the scheme which was introduced for people who are victims of flood and erosion, such eviction is neither justified nor reasonable. Such move for eviction, para. Sri J. Hendik, Learned State Council has, however, submitted that the present land over which the petitioners were occupying are grazing land which cannot be either occupied or even be allotted. Full stop. In this connection, he has placed reliance on the case of Jakpal Singh versus so and so. Full stop. He has submitted. No, full stop. So far as the scheme dated so and so is concerned, he has submitted dated 12/3/2015 is concerned. He has submitted that the scheme has been withdrawn, and therefore there is no question of consideration under the said scheme. Full stop. The Honorable Supreme Court in the case of Jakpal has clearly laid down that grazing land within bracket VGR are to be made encroachment free as those are community lands, and under no circumstances those are to be reserved for any allotment. Full stop. For ready reference, the relevant observations are extracted herein below. 23 as a as regards the claim to be considered under the scheme under notification dated 12/3/2015, this court, on taking into consideration that the scheme has been withdrawn, no directions can be issued for such consideration. Be that as it may, under the aforesaid facts and circumstances, this court is not in a position to grant any relief to the petitioners. Full stop. Accordingly, the writ petition is dismissed. Full stop. At this stage, Sri Goswami, the Learned Council, submits that their cases for rehabilitation may be considered in a humanitarian manner. Full stop. In view of the efforts of
And
submission,
also under my government land policy of 2009.
and also the existing
Yes,
policy.
land policy.
Existing land policy. In view of the aforesaid submission, it is provided that if the petitioners apply for such allotment under the existing policy, the same may be considered in accordance with law and accordance to law. Full stop. The applications, if filed, are to be disposed of expeditiously and preferably within an outer limit of 90 days.
Until such time they will be.
Not in
They
this
may
land.
be protected.
Not in this land. No, Vijay, and you have already there from 17. Interim order stands vacated.
There are existing structures, like even brick kiln, colleges, namghars, masjids. I have made clear meanings here.
Since the
Only till such
since
time.
the interim order has been vacated, the petitioners be afforded a period of 15 days. Of at least 15 days to vacate the premises, vacate the land.
All right.
Not so.
Attempted. See, Barua?
Lord.
Yes.
Subject matter is, my lord, we should start at the same way, because we have constructed road, that particular area. What happened, according to them, they got damaged beyond ROW, my lord, right of way. Means within right of way, whatever the land falls, we pay due compensation, my lord.
Yes.
And if it is beyond the right of way, any the land is damaged by dumping that this. As per our contract agreement, that contractor is to pay. For time being, if you keeping aside this one, thereafter what happened, there is some allegation, matlab, serious agitation is there between all the departments. Ultimately, what happened, government has formulated one damage assessment committee, my lord. Damage assessment committee to ascertain who are the people who are affected.
What is their claim?
Yeah, my lord.
What do you want, Mr. Barua?
My lord, we are seeking compensation, my lord. As per the inquiry report submitted by Revenue, Revenue has conducted inquiry of the entire damage by the National Highway and its agents, my lord.
Who will pay the compensation?
National Highway, my lord. But subsequently, this kind of submission has come, that some scheme has been, damage assessment committee has been made. Well, I do not know, my lord, whether our names are there or not.
That is why, my lord, what happened, initially I have thrown up our lordship, honorable court, I have requested him, once damage assessment committee is there, you are affected, you also go to them. When they have not gone, my lord, when we have sent a name to, this petitioner's name to the damage assessment committee. Now, we have sent, my lord, through affidavit I have stated, my lord, my affidavit is there.
What has happened thereafter?
Now, thereafter, what happened? Now, I am not aware, because in spite of our keep on requesting to Revenue Authority also, he give me whatever their names are there or not. But I'm not able.
Who is for the Revenue Authority?
Now, my learned friend has brought some
Yeah, for the
information.
Masao. Yes, what is your what are his information?
We recently got two lists, your lordship. One list is the persons who are within
Names
right
of the
of protection.
petitioners are there or not?
Not all, your lordship. Affected persons only.
Can you give a list to the Mr. Barua? Let him have an instruction.
Lordship, I didn't have him the copy, your lordship.
Heard Sri D. Barua, learned counsel for the petitioners. Also heard Sri C. Barua for standing counsel NHI. Para? Miss R. Deka, learned standing counsel.
NC Hills.
And CHEDC, not Kasar Hills Autonomous Concession, CHEC, has submitted that in terms of the scheme, a list has been prepared
Yes.
which contains certain names of the petitioners also. Well, the learned standing counsel is directed to furnish a copy of the list
Already given.
to Sri B. Barua, learned counsel for the petitioners, to enable him to obtain the instructions regarding future course of action, further course of action. Para? Ms. Deka has submitted that the list has already been furnished to the learned counsel for the petitioner in the court itself. Para? List for consideration when? After 2 weeks?
3 weeks, my lord.
17 matter.
Definitely.
After 2 weeks.
2 weeks after.
Good.
How will I do it?
Just go Malay, just go must go the police. Must go. That person that was after we better than no. That was a Panama. I'm about to Panama take you. Hey, I do in the blood. Hey.